wouldn't be possible without the hard work of Jen Avery, who was sort of the vision and also the yeoman behind this project. So if we could all just give Jen a huge round of applause. It's with great honor that I introduce to you our keynote speaker, Professor Nadine Strossen. Professor Strossen has been at the vanguard in the struggle to protect and expand civil liberties for most of her life. She has done so in her capacity as a lawyer, a teacher, author, and of course, in the leadership position she has held since 1991, president of the American Civil Liberties Union. Her courage and insight in the struggle for civil liberties has placed her among America's most 100 important women, 100 most influential lawyers, and 100 executives leading the digital revolution. I encourage you to read additional details about Professor Strossen's accomplished background in your program. But I wanted to share with you another way Professor Strossen has demonstrated her leadership ability in a subtle, seemingly unnoticed way. A few months ago, while she was speaking at Whitman College in remote Walla Walla, Washington, a friend of mine there struck up a conversation with Professor Strossen about the rhetoric being employed by the Bush administration to justify actions such as detaining people in Guantanamo Bay, the subject of this young man's thesis. Professor Strossen, interested and intrigued, offered to take the time out of her hectic schedule to read his thesis. A small act, but one that I think speaks volumes about the passion, concern, and humility that Professor Strossen brings to her role as a leader. Please welcome Professor Nadine Strossen.
Thank you so much for that wonderful introduction, Scott, and for that warm welcome. And you know, I always do learn from you may think it's a cliche, I know you hear it a lot, that we academics and others in leadership positions learn from our students and from audience members, but I really always do. And I enjoyed very much your colleagues' oral comments, and I must be quite honest, I haven't yet read his paper because I haven't yet read all the law review articles and books that I'm also looking forward to reading during the next semester break. I'm really honored to be taking part in this historic conference, the inaugural Duke Law Leadership Experience. And I would like to again thank Jennifer Avery, who has been my primary contact, and to congratulate Jen and Scott and all of the other Duke Law students who have participated in planning this conference. I'm really impressed by your efforts, and as they demonstrate your leadership. There's no better way to learn than by doing. As an old Chinese proverb put it, I hear and I forget, I see and I remember, I do and I understand. So, according to this proverb, since all of you student organizers of this leadership experience have all actually done leadership work through this experience, you have come to understand it. Selfishly, though, I hope that the first line of that proverb won't be completely true. I hear and I forget. I don't want you to completely forget what you're going to hear from me, but with that in mind, it was why I asked, and Jennifer agreed, that I would give relatively brief opening remarks to reserve a lot of time for your questions and comments and discussion, not only with me, but there are so many fabulous leaders in the audience. I'm almost embarrassed to be speaking to them. I would just like to mention a few with whom I've had the privilege of working very closely in the ACLU. Candy Carroll and Lynn Simon, who have been leaders of the ACLU nationally. You heard Candy this morning. They're both on your faculty now. And Michael Tiger, civil liberties lawyer par excellence, who is also on your faculty now. So I don't even know what I'm doing here, but they are certainly inspiring role models for all of us, yours truly included. And I would also like to introduce my wonderful ACLU colleagues from who are based right here in North Carolina. I hope that and believe that some of you already know them, but Jennifer Redinger, who is the executive director of the ACLU of North Carolina. And Jennifer, why don't you introduce your two staff members who are here, Ian and Paul? Or let them introduce themselves. Let them.
Actually, we have four.
Oh, I'm sorry, I didn't see the others.
Let me just ask, Ian Mance is our program associate at the ACLU North Carolina State Office. We're located in Raleigh. Paul Funderburk is our Youth Outreach Coordinator, building chapters in colleges and high schools all over the state and law schools. We have Sarah Preston, who could wave or something. Sarah's our new Legislative Coordinator, fresh out of Drake Law School in Iowa last year, passed the bar in Iowa, and came right to North Carolina. So that's, I'm sure, going to be real useful. Sarah is our face in the legislature, our lobbyist in city council, school boards all over the state and in the state legislature. And Sarah Harger from the Terry Sanford Institute, a graduate last year, is now our reproductive health coordinator. So I really invite all of you to consider interning in my office. I tend to hire interns when I have the opportunity to do so for temporary projects or for staff positions. So just give me a call if you're ever interested in volunteering.
That's wonderful, and it's so inspiring to me, especially I'm so delighted to meet the new staff members, a couple I have not met before, but Ian and Paul I had met before quite a number of years ago when they were student leaders of the ACLU at Appalachian State College. So a few more years and you'll be up here at the podium for the National ACLU. The point, I was consistent with my discussions with Jen, and she consulted with the other conference organizers. We agreed that I'm going to focus on general lessons about leadership, drawing on my own experience as a civil libertarian. But I hope that you will use the question and answer and discussion period to talk to me about not only those broad themes, but also any specific civil liberties issue that might be of concern to you. And then I understand we're going to have a reception afterwards where that kind of discussion can continue. The points I'm going to make about leadership now come from my own experience, not only as having the honor of being the ACLU president, but also having worked closely with many other leaders in other fields. Of course, I've worked especially closely with leaders in the public and not-for-profit sectors. I've had the privilege of knowing and collaborating with many top government officials around the United States and abroad, as well as the heads of many educational and public interest institutions from all across the political and ideological spectrum. I've also had the opportunity to collaborate quite closely with leaders in very different fields, having nothing at all to do with civil liberties or constitutional rights, everything from CEOs of major corporations to military generals. And what's interesting to me is how the themes of leadership resonate across all of those very diverse positions. Leaders and leadership qualities are essential not only in the most prominent public and private positions, but also at every level of our lives, including our local communities, clubs, our classrooms, wherever we are. Indeed, in terms of the immediate impact on your lives, the most important leaders may well be one of your teachers, the editor of your school newspaper, the head of a campus organization. That's especially important in terms of interests or values, or to take an example very close to home, the leaders of the student body that put together this wonderful experience that you're all partaking in. And important and influential leaders aren't necessarily people who have any official titles. Rather, they're people in all walks of life, from any background, in any setting, who demonstrate leadership qualities. They could include fellow students who take courageous stands on controversial issues by writing letters to the student newspaper or speaking out in class. And our leaders certainly can and should include every single student who is here today in every aspect of your own lives. So I hope that this excellent conference will help you to think about and develop and integrate into your lives certain personal qualities that can make you a leader, even if you have no official leadership position or title. You can still exert a positive influence over other people, be a positive force in their lives, and most importantly, you can live your own life, no matter who you are, to be true to your own best self. Conversely, no matter how many leadership titles or official positions you might have, you still won't be a leader, or you won't be an effective leader without these essential personal qualities. Now, one indication of the general importance of leadership qualities for all of us is the large and growing public interest in these issues. I just asked my assistant yesterday to look up the number of books that are listed on Amazon.com on leadership, And I was just astounded. It's 194,000 titles. The last time I looked at it, which was 10 years ago, it was only 13,000. So this has been an astronomical increase. All of these burgeoning materials about leadership reflect a consensus that there are some common positive qualities for leadership that span all fields of human endeavor, so that the qualities of an outstanding U.S. president, for example, are shown by leaders in every other realm. That was made very clear to me quite recently by a month-long interview series that National Public Radio, NPR, aired right before the last presidential election, when obviously we were thinking about voting for our top national political leaders. And NPR was expressly exploring attributes of political leadership and how they relate to other kinds of leadership. The series featured interviews of 4 leaders in very diverse fields: business, education, entertainment, and sports. And the students in this audience should be especially interested to know that one of the 4 leaders singled out in the education field was a student leader, Matthew McGann, who was then president of the MIT student body. And all of these interviews underscored 2 overarching conclusions. First, despite the very wide diversity among the interviewees in every respect, from age to background to field of activity, they repeatedly singled out the very same qualities as essential for effective leadership. And each one of them had been interviewed separately with no idea of what the others were saying, sort of like a jury sequestration. So they independently came up with the very same insights, or very similar insights. Moreover, the qualities they each stressed are the very same qualities that I've noted as a result of my experiences in very different fields of activities and interacting with a wide cross-section of leaders myself. So I'm going to list the 5 most important leadership qualities that these NPR leaders recurrently stressed as I've kind of processed them. I'm not going to list them in any order of importance, because they all agree that all of these qualities are equally important, and I agree with that. So in no particular order, the 5 important qualities of all leadership. First is a passion for one's pursuit, seeing one's work as a mission and a calling, and not in a sense of some grim duty that you're required, but to the contrary, really deriving a sense of joy from that work, even fun from it. Secondly, telling people the truth, even when it's hard, and correspondingly, taking people where they might not otherwise want to go, precisely because it's hard. Third, serving as an example for others and an inspiration, standing up and doing things, including hard things, yourself, and standing up for the people you are leading. Fourth, treating all others, including everyone for whom you are a leader, with respect and compassion, so you are therefore reinforcing your own commitment and dedication to the common enterprise. And fifth, a sound understanding of the area in which you are leading and an ability to communicate that so that the people you lead will have trust and confidence in you. I should say personally that I strive to live up to those aspirational qualities, not only in my ACLU work, but also in my capacity as a law professor. In a very real sense, excellent teaching is an essential form of leadership. We are leading our nation's young citizens toward fulfilling their full potential, both as individuals and as constructive members of our community. I always keep in mind that the etymological origin of the word educate, the Latin word educere, literally means to lead forth. Now let me turn to the second major theme that ran through the NPR leadership series, also completely consistent with my own experience. And it's related to the first one, which was the commonality of leadership qualities across very diverse fields. And the second point that emerged for me, very strongly, is another type of commonality in leadership qualities, and that is the commonality across time. Yes, we have faced very rapid changes recently. Still, I think the same fundamental leadership qualities for effectively navigating through this very new environment and leading other people through it are the very same qualities that served in earlier times in very different circumstances. One of the 4 interviewees in the NPR series was Jeff Bezos, the founder of Amazon.com. Of course, he was a pioneer, some would say the pioneer of the brave new world of e-commerce, and quite strikingly young by my standards. But the qualities that he singled out as explaining his success in leading others through cyberspace were also cited by older, much older interviewees in very established venues. Indeed, leadership often means precisely the quality of standing by established truths and principles in the face of economic, technological, social, political, and other new developments. And despite the pressure, resisting the pressure to abandon time-honored truths that might seem temporarily inconvenient in light of changing circumstances. That is certainly the case in my fields, constitutional law and civil liberties. Throughout American history, changing circumstances have constantly generated what Supreme Court Justice Oliver Wendell Holmes called hydraulic pressures to abandon core commitments to human rights and freedom. More recently, Justice Sandra Day O'Connor made the same point in an ACLU case. I'm proud to say, I'm sorry it was a dissenting opinion, but I will give it life here. In her words, it can never be too often repeated that constitutional rights are most often endangered in times of crisis. Now, she wrote those prophetic words before 9/11. Obviously, they have become even more prophetically, sadly, true since then. Too many politicians and pundits have been too uncritically calling for the sacrifices of established fundamental principles as the supposedly necessary price for national security. Not only in the current context, but also more generally, too many political so-called leaders have not in fact lived up to that label precisely because they yield to the shifting tides of public opinion, pandering to and even priming the public's fleeting fears and following every public opinion poll. Too many lack the political courage to stand up for principles and to do what is the right thing in the long run, not the popular thing in the short run. So they are the opposite of leaders. A few years ago, I guess it was about a decade ago, Washington Post columnist Richard Cohen captured this too prevalent pattern in a scathing column. He was referring to our very top government official at the time, namely our president, and Richard Cohen wrote, "When it comes to political courage, Clinton has mastered only the first half of the concept." Takes a minute for that to sink in. Well, given that barb against Bill Clinton, I hasten to stress that the ACLU always has been staunchly nonpartisan. We never support or oppose any candidate or official as such. Instead, we criticize or praise every one of them on an issue-by-issue basis. And unfortunately, when it comes to this leadership quality of political courage, the essence of principled leadership, on this crucial measure, too many elected officials fall short on both sides of the aisles and across the ideological spectrum. In the current so-called war on terror, very few members of the U.S. House and Senate have stood up against political pressure to fulfill their responsibilities in a conscientious and constitutional manner. In other words, to be courageous leaders rather than fearful followers. William Safire, who for many years was a New York Times columnist, arch conservative, had been a speechwriter for President Richard Nixon. He was so irate, and like he's a conservative libertarian, so he was very concerned about some of the violations of privacy and freedom of access to information, due process of law, that were sailing through, not only because of the administration's unilateral sense of its unfettered inherent executive branch power, but because Congress was letting them get away with it. And I remember Sapphire, who was such a great wordsmith. He still is. He's just not doing it in columns anymore. He said what Congress is doing be called undersight, not oversight. And again, that was so true on both sides of the aisle. After the September 11th terrorist attacks, then Attorney General John Ashcroft subjected Congress to extraordinary pressure, and I do recognize they were subject to extraordinary pressure to do something to show the public that they are concerned about terrorism. Of course, you can't do anything meaningful until you know what the cause of the terrorist attacks were, but there was extraordinary pressure before there was any analysis to ram through what ultimately became the USA Patriot Act just because the Attorney General was telling them to do so. Members of Congress who dared to ask questions about the law or even take the time to read it or analyze it were accused of being unpatriotic or even traitors. And I want to underscore that I'm not engaging in hyperbole here. I want to adhere to that principle of telling the truth. So let me justify that conclusion. For one thing, how did we get the name of that law? It's an acronym. They had to concoct this very verbose name to generate the acronym USA Patriot Act. Can anybody here, this is law professor calling a student, can anybody here tell me what USA Patriot stands for? You'd know it. Wow, let's hear it.
Uniting and strengthening America through
Almost.
protecting,
Okay, pretty good. Anybody take us a little bit further? Okay, I don't want to belabor the point. By providing appropriate tools required to intercept and obstruct terrorism. I mean, if you don't know what the acronym stands for, don't be embarrassed. You're in very good company. I'm sure, I know that most members of Congress who voted overwhelmingly in favor of it did not know what the acronym stood for because most of them admitted that they did not have time to read the 350-page complicated law before they voted for it. So for too many politicians, more important than what that acronym literally stood for is what it implied, namely, you sure are not a patriot if you dare to vote against this, or you sure are vulnerable to accusations, soundbite accusations of being unpatriotic in the next election campaign, and that surely had an impact. Moreover, when Attorney General John Ashcroft testified before the Senate a few months after the terrorist attacks, he actually said that those of us who raised what he derided as phantoms of lost liberty, he said we were only aiding terrorists and giving ammunition to America's enemies. And those of you who have studied the Constitution know that very closely tracks the constitutional definition of treason. When I say that he attacked us or accused us, I said that advisedly because I had raised these all too real concerns about lost liberty when I had the honor of testifying before that very same committee just 2 days before. On the Patriot Act, I do want to quote sort of humorous but also sadly insightful satiric definitions of current political usage that were in The Nation magazine a while back. They had two definitions for Patriot Act. The first is the preemptive strike on American freedoms to prevent the terrorists from destroying them first. And the second is the elimination of one of the reasons why they hate us. In the same vein, here's how the Nation's dictionary defines 9/11. Tragedy used to justify any administration policy. But again, in this context, I don't want to come down too hard only on the administration because there has been a lot of complicity here from other elected officials. And I also have to say a lot of support for civil liberties across party lines by an unfortunately small number, but still significant number of members of both houses on both sides of the aisle, and an extraordinary leadership from federal judges that I think we have not seen in any other national security crisis. And again, the line has nothing to do with the political party affiliation, the ideological affiliation of the judges or of the presidents who appointed them, but leadership in the sense of what I'm talking about, standing firmly committed to principle, even and indeed especially in times and settings when there is extraordinary pressure not to do that. And I think that is, as Thomas Jefferson said, I think he gave a much better definition of patriotism than John Ashcroft. He said dissent is the highest form of patriotism. Daring to do your civic duty of paying attention to what your government is doing in your name and calling attention to what you consider to be misguided or dangerous government policies. And that's particularly true patriotism and true political courage when it comes at the price of earning unpopularity at best, punishment at worst. That point was powerfully made many times by the person who was the most inspiring leader for me personally in my lifetime. That was President John F. Kennedy. For example, President Kennedy echoed Jefferson's thought in words that significantly are carved on the entrance to the John F. Kennedy School of Government at Harvard University. I don't know if any of you have ever visited it, but there are these very impressive brick pillars on the Charles River in Cambridge. And if you look closely as you enter it, you'll see some words carved there. And I think it's significant that these words, of all the eloquent words that Kennedy wrote, or some people say were written for him by his speechwriters, in any event, that of all those words, these were the ones that were carefully selected to be the first ones to meet the eyes of all the people who passed through those pillars, including some of the greatest and most powerful leaders now and in the future from all over the world. And here are the words that are on those pillars. He said, "The individuals who create power make an indispensable contribution to the nation's greatness, but the individuals who question power make a contribution just as indispensable, for they determine whether we use power or power uses us." In the current counterterrorism campaign, in addition to direct pressure from the administration itself, members of Congress also have been under great indirect pressure from public opinion polls showing solid support for most anti-terrorism measures. Not surprisingly, therefore, many members of Congress who had initially voiced concern about the Patriot Act, who had initially said they were not going to vote to extend provisions that were due to sunset recently, about a little bit more than a year ago, trimmed their sails and ultimately, under great pressure, put aside what they had said were their serious principled concerns about the law. Now, I don't want to be overly critical of them. I really do sympathize with the tremendous pressures they were under. But that very fact, how great those pressures were, to me underscores the extraordinary leadership of those few members of Congress who resisted the pressure and stood tall for constitutional principle in voting against the Patriot Act. In the House, there were 66 such members, and in the Senate, there was literally only one member of the entire United States Senate who voted against the Patriot Act. That was Wisconsin Senator Russell Feingold, and he was also the only member of the Senate to cast a vote against a procedure called unanimous consent, which would have cut off all debate and all amendments about the Patriot Act. So that, to me, is an example of true leadership. And Feingold was up for re-election. He had been elected by a razor-thin margin. He was facing a very tough re-election campaign. This was something that he did despite the fact that it was not good for his electoral prospects. In my book, this is true leadership, and it earns him a chapter in my favorite book on that subject, which you won't be surprised because I already told you one of my heroes in this vein. So I'm referring to John F. Kennedy's classic work, Profiles in Courage. And somebody has told me that supposedly he didn't write it, but to me it's like, I don't care who wrote Shakespeare. You know, it's a wonderful, wonderful book, regardless of the provenance. And I had read it initially as a very young person when it had first come out, recently reread it, and I found that it really stood the test of time, giving various biographies of people throughout American history who had risked their political careers, in many cases sacrificed their political careers to do what they consider to be the right thing. I would now like to cite some profiles in courage other than prominent government leaders that we've all heard about. In particular, since this is a conference of young leaders, I want to cite examples from that group. One of my greatest sources of inspiration as ACLU president has been the chance to work with extremely impressive young women and men. You've been introduced to some of them already today. Who show all of the leadership qualities I've been describing at a very young age. And I hope that that will be a role model that you may find even easier to emulate than role models such as John Kennedy and Russell Feingold and Candy Carroll and Len Simon and Michael Tiger and the older ones of us in this room, because I'm going to tell you about people who were extraordinary leaders, showed extraordinary political courage, had an enormous impact in advancing justice in their own communities with nationwide impact and even beyond nationwide impact at a very early age. I'm going to tell you about people who were teenagers or pre-teenagers. And these, you can read about many inspiring examples of the young people who have been ACLU clients, who have actually dared to stand up for their rights, to go to court, and by standing up for their own rights, earning legal rulings or changes in policy that redound to the benefit of everybody in their communities with literally global ripple effects. You can read about many of these young students, student leaders or other young people on the ACLU's website. Among other things, it features information about the youth activists who have demonstrated civil liberties leadership, whom we have been singling out in the last few years. There's a nationwide search, and we've been awarding a few scholarships for some of these young leaders each of the last few years. I'd like to first tell you about one of these outstanding young leaders who won one of these prestigious scholarships in 2005, is from right here in North Carolina. So I'd like to share with you our website write-up about him. His name is Jared Gamwell. He is an ACLU client who made national headlines for speaking out against censorship. Jared sought representation from the ACLU after posters promoting his campaign for student body president were torn down by officials at Hunt High School in Wilson, North Carolina, because his campaign slogans referred to the fact that he was openly gay. After discovering that two of the posters had been taken down, one with the slogan, "Queer Eye for Hunt High," and another reading, "Gay Guys Know Everything," Jared went to school administrators only to be told that it was the principal who had ordered the removal of the posters. Now, how many people would persist at that point? Instead of backing down, Jared reached out to the ACLU to sue the school for discrimination, and his lawsuit received widespread media attention. He continues to use it as a springboard for raising awareness of the sanctioned discrimination faced by LGBT youth in schools across the country and working to make the schools safe for them. So very inspiring example from right here in North Carolina. I'd like to cite just a couple more specific examples of these inspiring young civil liberties leaders who have spearheaded ACLU cases, and these will be cases in point to how can the law and how can leaders in the law, including young leaders who are acting as clients, standing up for their own rights without any fancy titles, how do they bring about social change? How do they bring about justice? The first case I'd like to talk about involves a student who was then a 16-year-old junior at Dearborn High School in Michigan. This is a couple years ago. His name was Breton Barber. Brett's goal is to become a constitutional lawyer, and in fact, while he was still in high school, he came amazingly close to realizing that goal. He not only believes in constitutional rights in the abstract, he actually insists on exercising them in his day-to-day life, and that's the hallmark of what I call a civil libertarian, but what other people call troublemakers. It's one thing to have these rights on paper and in theory, but you want to exercise them, go home. In addition to being a civil libertarian, Brett was deeply opposed to the war in Iraq, and he's been very active in the peace movement. So he decided to go to school wearing a T-shirt with a very attention-grabbing anti-war message. And he chose, just so you know the whole factual context, he chose that T-shirt on that day because it illustrated a presentation that he had been assigned to make in his English class that day. The assignment was a compare and contrast essay, and Brett chose to compare and contrast, this is provocative, President Bush and Saddam Hussein. And I said it's provocative, and before I go any further, I want to stress the ACLU never takes any position on any foreign policy issues, such as whether the U.S. should go to war, but we have always defended the rights of individuals and groups in our country to express their own views on these very important issues. And it's so interesting what we always end up, by definition, defending freedom to express whichever perspective is unpopular in the particular community where it was voiced. And I have to say there have been a couple instances in connection with the war on Iraq where we have had to come to the defense of people who are marching in favor of the war, because that's very unpopular in their communities. And then in other communities we have to come to the defense of anti-war protesters where that viewpoint has been unpopular. As it happened, Brett's T-shirt provoked no negative comment from anyone at all, and he said that a couple students actually had expressly complimented him on it. But at lunchtime, the vice principal came up to Brett and told him he couldn't wear the shirt because it promoted terrorism. Promoted terrorism. Now let me tell you what the T-shirt actually said. You make your own judgment. I'm not going to draw any conclusions here. The T-shirt showed a picture of President Bush between the words international terrorist. The school's dress code bars any clothes that promote drugs or alcohol, and the vice principal said, well, by extension, it also bars your T-shirt because your T-shirt promotes terrorism. But Brett had done his homework. See, this comes to another one of those leadership qualities, knowing what you're talking about. In that sense, you'll see he shows more leadership than his school principal did. Brett had actually read the landmark 1969 Supreme Court decision that first upheld students' free speech rights, Tinker versus Des Moines School District, which is an ACLU case, I'm very proud to say. And of course, it was the ACLU volunteer lawyer on the case was somebody who had just graduated from Drake Law School. And so, again, talk about leadership. If you want to use your law degree to have the chance to represent courageous clients of the sort that I'm talking about and to make landmark history through the Supreme Court, there's a very good opportunity waiting for you as an ACLU lawyer. Michael Tiger was telling me he had a similar experience as a very young lawyer getting to argue a very important case in the Supreme Court, and I hope you'll talk about that later on. So this is a recruiting call. Anyway, in that case, the ACLU represented Mary Beth Tinker, who was only 13 years old when she went to school wearing a black armband to express grief for the people who had been killed in Vietnam and to protest the war. That was a very controversial opinion back in the mid-60s in the Midwest. I can assure you that's exactly where I hailed from, Minnesota at exactly that time. But the Supreme Court strongly upheld Mary Beth's rights and the rights of all students and teachers in a historic opinion. Its most famous phrase has been quoted countless times since then in other important cases. The court declared students and teachers, as a teacher now I like that part of it, students and teachers do not shed their constitutional rights at the schoolhouse gate. And the court held that students and teachers may express any idea or opinion, even if it's provocative or offensive to many in school, so long as it does not cause a material and substantial disruption of the educational process. Now, in the recent case that I was describing, not only had Brett Barber done his homework in researching the Tinker case, he also did his legwork. Again, a 16-year-old kid, no sooner was he thrown out of school for wearing this T-shirt, the one that caused terrorism, then he made 2 calls. First, to the closest ACLU office, and second, to the media. One of Brett's reasons for wearing this shirt had been to spur thought and discussion, both about the war in Iraq and also about the free speech rights of students and of peace activists. And in that goal, he ended up succeeding beyond his wildest dreams. He was interviewed on primetime national TV. News stories about the case appeared all over the United States and a couple foreign countries. And I'm going to give you just one quote from one of the New York Times stories about this case. It recounts Brett's meeting with his principal after he resisted the vice principal's ultimatum that he either take off the T-shirt or go home. And you'll see why I say that Brett was already a budding constitutional lawyer even as a high school student, in his words. So the principal immediately asked if I was familiar with the Tinker case. I said I was very familiar with it. She said it happened in 1969. And I said, no, it happened in 1965, but it got decided in 1969. Then she quoted from the case to say that the school has the right to control speech. But I pointed out to her that she was quoting from the dissenting opinion, not the majority. In fact, Brett was right about the law and his principal was wrong, so it's not surprising that the ACLU prevailed in the lawsuit we brought on his behalf. As always, we tried to settle the suit because it's a shame to waste everyone's time and the taxpayers' money in what was inevitably a losing battle for the school, given the longstanding Tinker precedent. Unfortunately for the government treasury in Dearborn, Michigan, but fortunately for the First Amendment, we did prevail. But you see, given that stubbornness of the school officials, even forcing us to litigate that case, even after presumably the school's lawyer did read Tinker's majority opinion, that stubbornness clearly shows that the only thing that made them comply with clear First Amendment commands, strong Supreme Court precedent, was Brett's courageous leadership. And that is so characteristic of so many of our cases. No matter how misguided the officials are about the law, no matter how unjustified the officials are in suppressing individual rights, the officials will still prevail, and the rights will still be suppressed until or unless someone is willing to stand up, someone who knows his or her rights and dares to assert them. And these people are defending not only their own rights, but those of other people in the community. I have to tell you one other quote that I remember from the New York Times, and it was a story that appeared, I don't know, probably more than half a dozen or so years ago now. After we started seeing more and more students with their own computers at home, high school students who would create their own websites and on their websites have material that school officials got wind of and somehow thought were offensive, the common theme was that these websites dared to have humorous and even critical observations about teachers and school officials. And we just had this whole spate of cases all over the country where students were being expelled for creating their own websites on their own home computers, on their own time, daring to, if you will, dissent, to criticize a government official, which is what a public school teacher or principal is. And these are clear violations of First Amendment principles, as all of you who have studied constitutional law know, and yet the school officials were intransigent all over the country. We were bringing lawsuits. Many of them settled, but many of them did not. And the New York Times at one point decided to write a thematic article about a number of these cases. And I will never forget the story included an interview of a principal it was a suburb of St. Louis, Missouri, who was explaining why, on advice of counsel, he had finally decided on behalf of his school district to settle the case. I guess it was the superintendent of the school district. So the New York Times quotes the school superintendent as saying, "We settled because there was a technicality in the student's favor," whereupon the school district's lawyer says, "The First Amendment." This is a very serious subject, but I want to tell you a story about another ACLU case involving similar issues, and this one also comes from Des Moines, Iowa. It also involves very young student leaders, and it has a lighter side. For me, I have to say, humor is a saving grace. I believe it's very important to be able to laugh about even the most serious things. Indeed, especially the most serious things. Indeed, it's very important to be able to laugh about even yourself and even your own most cherished beliefs. So in that spirit, as my ACLU colleagues know, I'm always happy to make good-natured fun of everyone, including the ACLU. And one of my favorite anecdotes in that vein goes back quite a long time now to when we had just started our website, and I'm proud the ACLU had one of the first websites of any such organization, and we were running a contest on it for different things that our acronym could stand for other than American Civil Liberties Union. Our detractors are always coming up with supposed meanings that I see everywhere, from fundraising letters of oppositional organizations to graffiti in bathroom stalls, everything from all criminals love us to always causing legal unrest. But in this contest, my very favorite was, "Oh, come on, lighten up." So I really do try to put that into practice, and to illustrate, I'm going to give you another example about inspiring student leaders who themselves used humor to convey a very serious message and to achieve important reforms in their community, an example of leadership within their community. It involves young female students. Actually, it was in Ames, Iowa, sorry, not Des Moines. Just like the now legendary Mary Beth Tinker herself, these young women were still in middle school when they also became leaders in standing up for rights. I'm a founder of a group called Feminists for Free Expression, so these particular young women were very much after my own heart. They were equally committed to both women's rights and free expression. On the one hand, as feminists, these young women were concerned about sexist expression, including sexually suggestive sexist expression. On the other hand, as free speech supporters, they did not want to censor or punish that expression. They just wanted to counter it with their own pro-feminist views. Now, specifically, these young middle school students were concerned that some of their male classmates were coming to school wearing Hooters T-shirts. Now, as some of you may know, Hooters is a restaurant chain that, at least at that time, featured waitresses with suggestive outfits, calling attention to certain portions of their anatomy. And these particular Hooters T-shirts showed the owl, and the owl, of course, is one of the connotations of the word Hooters. And this T-shirt was designed with the owl very provocatively placed with its eyes strategically right over the nipples of the person wearing the T-shirt. So these young women were quite concerned that their male classmates were coming to school wearing these T-shirts. And to add to the provocation, the restaurant's slogan on the back of the T-shirt was, "Hooters, more than a mouthful." Well, they didn't want censorship, so they put their creative counter-speech into action, and our young female clients came up with quite a provocative T-shirt of their own that they started wearing to school. On the front, instead of an owl, it showed a rooster. And on the back, the corresponding slogan was, "Cocks, less than a mouthful." And that is when the principal decided to intervene. Interestingly, he hadn't censored the boys' T-shirts, but the girls, he said, "You got to take those off or leave school." So, I don't want to get too much off into substance, but it's a pattern that you see so often. It's those who are asserting rights of women and a feminist perspective that tend to get censored disproportionately. But the ultimate outcome here was positive. Our young clients organized public forums. They discussed the constitutional issues. They had a huge amount of media attention, as you can imagine. They wrote an article about their case for the leading teen magazine nationwide, and they successfully negotiated with school officials to preserve both gender equity and free expression. I'd now like to tell you about just one more courageous young ACLU client. I picked these cases because I think they're particularly interesting for law students. And this one was involved in one of our most recent students' rights cases that went all the way to the Supreme Court. Her name is Lindsay Earls. Some of you may have already studied this case. Along with Mary Beth Tinker, her name is now part of constitutional history, and thus an important part of the future. The case bearing Lindsay's name is Board of Education versus Earls, and I remember Erwin Chemerinsky, your wonderful faculty member and a great colleague and friend of mine, co-authored a very important amicus brief in this case in which the ACLU was directly representing her. It was a landmark challenge to the spreading phenomenon of public schools, subjecting all students who are involved in any co-curricular activities to urinalysis, drug testing on a mass, random, suspicionless basis. Now, when Lindsay decided to start this historic lawsuit, she was a 16-year-old high school student who had spent her whole life in a tiny town called Tecumseh, Oklahoma. She had always been a model student. She was a leader in the school's choir and academic team. Nonetheless, or I should say, therefore, when her school told its leading students, the ones who were engaged in these extracurricular activities, inter-school activities, when the school told these excellent students that they had to, not to put too fine a point on it, pee in a bottle in front of a teacher to prove their innocence of drug usage, Lindsay's conscience impelled her to challenge that violation of privacy and freedom. She had never used drugs. I don't think she would know what a drug looked like if you put it in front of her. She was such an innocent, still is, I should say. And she passed every drug test to which she was subjected, but that was not the point. And here's what she said. I felt like it was an invasion of my privacy and my Fourth Amendment rights, and that the school was stepping into the parents' realm. They were trying to take responsibility away from my parents. I knew no one else at my school was going to take a stand, so I felt like I needed to do it. Now, Lindsay describes herself as a goody-goody two-shoes who surprised herself as well as everyone else by taking this principled but unpopular stand. One interviewer asked her, "Where did you get the strength to say, wait a minute, this isn't right, and I'm going to do something about it?" Her answer reflects the classic leadership qualities that I've already described, including a passion for one's pursuit and serving as an example and an inspiration for others. She said, I felt really strongly about it. It was something that needed to be done. The school had to be held accountable. If no one challenged the school's drug testing policy, then the school would be able to get away with other things as well. If they began patting us down or strip searching us, I felt like it would have been my fault, because I had felt strongly enough about this, and I hadn't done anything about it. The federal appellate court that heard Lindsay's case issued a strong ruling in her favor, and thus in favor of the constitutional rights of all students at all schools. Later on, the Supreme Court ruling was not so favorable, but at the time of the appellate court decision, Lindsay was so inspired by this experience that she changed her future plans to become a teacher and decided to go to law school instead. In her words, I've seen that you really can change someone's life through the law. Our Constitution is a beautiful thing, and people need to be willing to stand up and fight for it. She also said, I've learned that even though someone is young, you can definitely make a change. If there's something you don't like, you can do something about it. Just go for it. And I really can't think of a better tagline, so I'm almost done. I want to say whatever your own passions might be, follow what, as Lindsay said, just go for it. And I can assure you, based on the anecdotes I've given, which are completely representative of the ACLU's work at all levels of government all around the country, people do make a difference, an enormous difference, by speaking up. And I also can tell you this, that if you do not speak up, your silence will also make a difference. So it's your choice. You will have an impact through either speech or silence. And on that note, since we celebrated Dr. King's birthday earlier this week, I want to quote just one of his very eloquent and powerful observations, and it came during a seemingly hopeless moment in the early history of the civil rights movement. He said, "What we will remember is not the words of our enemies, but the silence of our friends. So in that spirit, in closing, I would like to quote my favorite ACLU t-shirt. You see the t-shirt theme is a very big motif here. Thanks to TV and movies, everyone knows that you have the right to remain silent. But this t-shirt reminds you of another right, which is at least as important. You have the right not to remain silent. And in a nod to our former Attorney General, John Ashcroft, I would amend that slightly to say, you have the patriotic duty not to remain silent. So please exercise it and enjoy it. And if anyone tries to stop you, you know you can call the ACLU or become an ACLU lawyer. Thank you. Michael, not to put you on the spot, but could you tell us about the case you handled as a young person? As an even younger person than you are now?
Thank you. Well, when the Vietnam War draft calls went up and up, an increasing number of young men protested the war and protested the draft by turning in or burning their draft cards. So they subjected themselves to criminal prosecution, but General Hershey had a better way. He simply had the local draft board immediately strip them of their deferments, classify them 1A, and accelerate them for immediate induction into the armed forces. 3,000 young men refused to submit to induction and were in federal prison. The Supreme Court granted certiorari in a case called Good Connect against the United States, and Mel Wolfe, who was then staff counsel of the ACLU, called and said, would you like to brief this case and cases about judicial review and argue them in the Supreme Court? And I'd only been a member of the bar for about a year and a half, and I said, well, to be a lawyer, you have to have this massive ego suspended over a chasm of insecurity. And, so my massive ego spoke up and said, well, I could do that job. And we won 8.5 to 1/2 because Chief Justice Berger really couldn't understand it. All that. But the other 8 got hold of the concept, and there it was.
When Sarah Weddington argued Roe versus Wade, she had only been, and her co-counsel had only been out of law school for about 1 year, and there's a wonderful book that's very much along the themes that I talked about in my concept of leadership that's still in print, even though it came out a long time ago, called The Courage of Their Convictions. It's written by Peter Irons. Some of you may have read some of his work. He's a lawyer as well as a political science professor, and he runs the Earl Warren Bill of Rights Institute in California, UCSD, right? And Peter had been a conscientious objector during the Vietnam era, actually went to court and took his case through the first level of federal court, the trial, and he found that even having such strong convictions himself, it was such a hardship to go to court. Those of us who just read on the printed page, I think really can't imagine what it's like to be there in person, especially for the client, the person who is really risking his or her freedom and reputation, as well as financial resources, psychology, you name it. And when Peter went to law school, as he was studying constitutional law, he thought, gee, we're only reading about the issues, the law. I'm really interested in who are the people behind these names, Roe versus Wade, Tinker versus Des Moines, who had the courage to go all the way, not only through the trial courts, but all the way to the U.S. Supreme Court. And he then did this marvelous book where he picked some of the most important and interesting cases in constitutional law, and each chapter is divided into 2 sections. The first is a really helpful summary, even for non-lawyers, of the significance of the case legally, and the second part is the story in the person's own words of what it was that motivated them to do it. And they come from every walk of life. That's so inspirational. Every race, gender, age, economic background, occupational background, every part of the country. The one thing that unifies them is the courage of their convictions. Another theme that I saw going through the book that Peter didn't consciously note is how many of the lawyers that were involved in those historic cases. Sarah Weddington being one example, because one of the cases he talks about is Roe versus Wade. But there were so many lawyers who were so inexperienced, had just graduated from law school. And I don't know if it's a coincidence or it may just be that these were cases that seemed hopeless, and so it was only lawyers who had just opened up storefront offices or were that were willing to take the cases. But I guess I don't want to get too fixated on you too can go to the Supreme Court if you become an ACLU volunteer lawyer, because I really do want to emphasize that even if the case only goes to the trial court level, or even if the case is settled because of that technicality of the First Amendment, that you get the government official to recognize that that is still having such an enormous impact. And all of you, by virtue of your legal education, have an especially privileged opportunity to be able to have an amazingly significant impact the minute you graduate from law school, indeed even while you're still in law school.
One of the things that has perplexed me is you talked about the Amazon going from 13,000 to 194,000 books on leadership. One thing that I found perplexing that was reflected in your talk too is that there's been an incorporation of ethics, if you want, or a normative ethic into definition of leadership. And I'm wondering, and yours, truthfulness, serving as an example of inspiration, treating others with passion, respect, confidence, not necessarily, and passion on so. But those normative things have become part of most of the major theories in leadership that are academic theories. I'm wondering if you have some thoughts on why that is, and then the question of, is leadership good? That is, I don't mean leadership as opposed to being a follower. I mean different leaders. You have Genghis Khan and Frederick B. Taylor and Hitler, and those seem to be leaders, and yet they seem to be definitionally excluded, for example, from your qualities. They definitionally.
I don't, I haven't thought about this profoundly the way I'm sure authors of at least some of those 193,000 books have, but I certainly would be neutral in terms of the agendas that people are advocating, and I would recognize as a leader somebody who was advocating for positions that are very different from mine. In fact, I probably talked longer than I thought I was going to, but I left out a lot of notes that I had, and one of the notes that I had, I was going to give an example of just within the past week. I have dealt with both the leader of a pro-life organization, to use the preferred term of that group, and a pro-choice organization, and they're both people that I respect as leaders, despite the fact that they have very different views from each other, and one of them has very different views from mine on a particular issue. But I respect him because I believe he is telling the truth in his advocacy. Now, your question would be, suppose he were lying and he's an effective leader. Well, I guess, that's why my personal definition incorporated being true. Well, I'm sorry, it's not, I can't answer your conundrum, because I did talk about being true to your own principles. So I guess that would make you a leader. It wouldn't be one that I would admire personally. And I think you raise a very good point, which is that there should be some, or maybe this is not your conclusion, but my conclusion is that we should not venerate leadership qualities in a vacuum. We should say, toward what end are you using those leadership abilities? I, again, with the disclaimers that the ACLU and I in my ACLU capacity never advocate for or against a particular person, but I will tell you, I'm harshly critical of Bill Clinton because I think he was so gifted in so many ways, with so many leadership qualities, and I think he really squandered them in terms of his own agenda. Right? I'm not even judging them relative to my personal principles, and I think in some ways you want to judge somebody against the potential for what they could have achieved versus what they did achieve. No more questions? Well, as a law professor, I suppose I could ask a question, but I also realize we've probably exceeded the time that people expected to be here. Okay, so I see two hands. Well, Michael, we'll call on the other young person first. Okay, since you.
Okay. I guess as leadership is the theme here, and as a leader, you are a part of this organization that espouses certain values. What do you do personally when the organization represents values that might be in tension with your own beliefs?
That's a really good question, and I'm not fighting the non-hypothetical by saying I've literally never been in quite that position, but let me explain why. That is because everything that I can think of that I'm aware of that the ACLU has done since I have been involved at the leadership level has been something that is consistent with civil liberties principles. Now, saying that still leaves enormous room for disagreement, as my friend and National Board colleague Candy Carroll can attest, and Jennifer can from her board debates in North Carolina. People who are committed to the very same general principles may have very strong disagreements with each other about how to apply them in a particular case. That becomes particularly true and problematic if you're talking about the many situations where there are more than one civil liberties principle that are involved in the same situation. So let me give an example that ties into something I mentioned, which is freedom of speech, equality of opportunity, regardless of gender, and that includes freedom from sexual harassment, expression that somehow undermines your equality as a woman, your equality of opportunity in the workplace or the educational setting. And we also, and I also strongly defend freedom for sexual expression, including sexist expression, including sexually suggestive expression. So when you're in a workplace setting or an education setting, how are you maximally faithful to all of those civil liberties concerns? And the ACLU National Board had, many debates about crafting a policy that we felt would protect against harassment in the workplace, sort of giving maximum fidelity to both sets of concerns that were somewhat in tension with each other. I think I happen to agree with the way that came out, but if it had come out slightly differently, I could completely, straightforwardly, candidly have defended it because I would have understood the principles that went into the discussion. And I have been on the losing side of some of those kinds of debates, and even though I think that ultimately I would have preferred a different solution, the one that came out is certainly one that is defensible with fundamental civil liberties principles. In a hypothetical situation, if my colleagues on the ACLU National Board, which is what sets the policy, did something that I thought was fundamentally inconsistent with civil liberties, I think I would have a responsibility to speak out, and that would require resigning, right? Because you can't, you would have to dissociate yourself at that point. In the ACLU's history, I can only think of one example, and this is way before my time, so it's historic hearsay. I don't know if anybody knows this. I heard that at one point we had a board in one of our states that adopted a pro-life position, completely opposing a woman's right to choose, and then they became disaffiliated with the ACLU. Let me just, if I can give one example, people often cite as what they think of as, it certainly probably was the most controversial position the ACLU took in terms of its own membership in the late 1970s in Skokie, Illinois, when we defended the free speech rights of neo-Nazis to demonstrate in a town that had a large number of Holocaust survivors. And many people know that my father is a Holocaust survivor, so they asked me, wasn't that hard? And that to me is not hard at all. Because you're defending a principle, you're not defending a particular message. And that principle of freedom of speech, even for offensive, unpopular speech, and thank goodness we live in a community unlike Nazi Germany where that is deeply offensive and unpopular expression, but the free speech principle is what's so important.
Oh, thank you for coming to speak with us. It's very inspiring. Thank you. I was hoping you could share with us the top issues that the ACL is working on nationally and the top agenda items.
Yeah, it's so hard to choose. We were so busy, if I have to summarize our agenda in a soundbite, I always say it's defending all fundamental freedoms for all people against violations by United States government officials. That's a pretty broad agenda, as you can understand, and includes everything from A to Z, or affirmative action and abortion to zoning, all of which are real issues. We were working full tilt on all of those on the morning of September 11th, and then suddenly we had a whole new agenda superimposed on top of that. So let me start with that. The post 9/11 assaults are endless, and the ACLU, I'm so proud to say, really has, with the help of a lot of allies across the political spectrum and other civic organizations and grassroots activism, has done far more damage control and had far more victories than I ever would have thought in my wildest imagination, both when I think back to that incredibly fearful climate right afterwards where you couldn't say anything remotely critical of the government. Remember Bill Maher being fired? Well, maybe it was tasteless, but I mean, it was considered to be worse than tasteless. It was just like dangerous to raise your voice in anything other than fear, shock, and awe. And we have, although there have been some setbacks, we've won stunning court victories, including from a Supreme Court that is so disposed toward presidential power. It really, in some ways, is a reflection of how extreme this administration's claims of power are, that even this Supreme Court, with its expansionist views of executive power, would say the president had gone too far in the enemy combatants case, had gone too far in the Guantanamo Military Commission's case. But, they keep bouncing back. I saw just in today's New York Times, the government has adopted rules for these military tribunals that are still so violative of the most fundamental due process in the Geneva Conventions. With respect to the examples are legion, but I'm just picking a couple that happen to be in the news today. Also, what is a not trivial, but unfortunately not definitive victory in the National Security Agency, NSA, domestic spying matter that the New York Times disclosed at the end of last year, where the government is unilaterally, without going to any court, even the super secret FISA court, spying on the emails and telephone communications of seemingly everybody in this country, and the ACLU won a lower court lawsuit against it. We don't think it's a coincidence that 2 weeks before that case was to be argued on appeal, and the day before he testified, which was yesterday, Gonzalez testified before the Senate Judiciary Committee. Suddenly, the administration says, well, we are going to get authorization, but from the super secret FISA court, so none of us knows what, it's a completely secret proceeding, completely ex parte, no right of appeal, so none of us knows exactly what the FISA court has authorized, so we're certainly not going to give up on that effort to defend freedom and privacy for everybody in this country. If I can mention just, there's so many categories of post 9/11 issues, but another one that affects everybody in this country is the enormous crackdown on First Amendment rights, not only rights of protesters of all sorts, and Brett Barber was part of that much larger pattern, but regardless of what your views are, everybody post 9/11 has been denied the aspect of the First Amendment, which is freedom of information. This government has acted with just astonishing and unprecedented secrecy in denying basic information about what it is doing to everybody in this country, to the press, where there have been secret court proceedings based on secret evidence. We're not able to challenge even the most vile allegations of abuse and torture, which is another major issue because the government at every turn is raising something called the state secrets privilege, something that it has taken, and unfortunately with the support of most lower courts, the acquiescence of most lower courts, basically asserting that even to have to defend against charges of even the most massive human rights violations would compromise national security. So we're essentially being denied due process for victims of torture and abuse. So that, a whole host of post-9/11 issues. If I were to link together, and then I'd like to hear from Jennifer what she would say about North Carolina as an example of what's going on nationwide. If I were to link together thematically a lot of other challenges we face, a lot of them have come from the over-politicization of religion. And believe me, the ACLU so strongly defends freedom of religion, freedom of expression for religion, but we do not believe, unfortunately, the Constitution prohibits enacting into public policy something simply because it is consistent with certain religious beliefs. And there are a whole series of policies that deprive people of liberty, are bad in terms of other public policy concerns, only because they're consistent with certain religious beliefs. The whole controversy about stem cell research being an example that's been in the news recently, the whole intelligent design controversy in which the ACLU, again, this is a good example of where the courts really have stood tall for constitutional values, but the attacks on women's rights and lesbian and gay rights and reproductive freedom, these are still ongoing. And then, all of the Roger Baldwin, who was the principal founder of the ACLU, said no fight for civil liberties ever stays won. I wonder, and I guess you also have to say no fight ever really is won. When you think of the for me, the greatest civil rights, civil liberties victory in the 20th century was Brown versus Board of Education, but we're still fighting so hard for racial justice, even starting with, the situation of racially segregated schools all over the country, and that's an issue that's before the Supreme Court right now. Speaking of racial justice leads in one breath to the criminal so-called justice system, where we are just, incarcerating and prosecuting and executing completely disproportionately on the basis of race, which in turn leads to, it's a perpetual cycle of injustice because we have these felony disenfranchisement laws which put the United States off the charts in terms of international law. One of the international human rights organizations just wrote a report together with the ACLU, and we're unlike any other modern democracy in disenfranchising so many people who were convicted of non-violent drug offenses being then permanently denied the opportunity to have some influence on the electoral process, which in turn passes these laws that create these injustices. So if I could just go on and on. It was internet censorship. We've in law school you will study ACLU versus Reno versus ACLU, the landmark case in which the Supreme Court agreed with the ACLU 9-0 that the internet should be protected, struck down Congress's first cyber censorship law. Congress just went back to the drawing board and passed another one, and we are still litigating that. It's been to the Supreme Court twice, and it's en route for the third time. So we're very busy, and I just want all of you talented young lawyers out there to know, I guarantee you there will be so much important work for you to do to advance justice. There's not a snowball's chance in hell that we're going to have cleaned up all the problems before you graduate. Did I see another hand over here? Then, Michael, you wanted to say something? Or ask something?
Your question
Yeah,
asked about ethics.
Yeah, I think that's a great question.
Rule of Professional Responsibility 3.6,
That's right.
as amended after the ACLU was an amicus in Gentile versus State Bar, where I represented the lawyer, points out that lawyers have a duty of leadership as public citizens, as Dom Gentile did in exposing corruption in the Las Vegas Police Department.
Wow.
But at the same time, we also have a duty as lawyers not to do that in a way that compromises the ability of the system that calls itself justice to give people fair trials. And that is a duty that extends also to district attorneys who have a duty to exercise leadership to deal with criminal behavior, but also to do so in a way that doesn't compromise the interest in fair trials. So for lawyers anyway, there's a star to steer by with respect to qualities of leadership.
And
But
I
that
was,
is the rules of professional responsibility that impose this
that's-
duty on us.
that's so interesting. I was thinking your very interesting question would have been a great topic for discussion among us.
There's a
But,
panel this next week, next Thursday, here in this room
Wow.
about that subject.
wow, great. Jennifer, can you tell us what the major issues are here in North Carolina?
Well, what she said. It's a lot of the same stuff, whether it is religious liberty, free exercise, establishment clause issues. The Ten Commandments stuff has died down a little bit since McCreary kind of explained that you can't do this. So we haven't had a whole lot of that lately, but we're still monitoring some communities. We have a really great, fascinating case. First time this has been litigated anywhere in the country ever, right here in North Carolina, around the practice in our state courts of when people are sworn in to testify or sworn in as jurors in North Carolina. Our statutes give you three choices as to how you go about that. You can either affirm, which is the secular option. You can swear a religious oath that everyone sees on TV. I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. And you raise your hand in the air. Or there's a third option. And the third option is to swear the religious oath and lay your hand on what our statutes call the Holy Scriptures. This has never been questioned, never been challenged until 2003, when a Muslim woman in Guilford County in Greensboro, North Carolina, was testifying in a domestic dispute, a domestic case, as a witness, goes to be sworn in, and she's handed a copy of the King James Version of the Bible. This is the only book that the Administrative Office of Courts purchases in North Carolina for use in our oath, administration of oaths. So she asked, could she have a Quran? She wants her oath to mean something. It's not going to mean a whole lot on the Bible, as much as it would anyway if she were laying her hand on the Quran as she swears to tell the truth, so help her God. How about having it be a reference to her God? The judge said, we don't have any. We need to get on with this case. So they had a discussion, and she was under the impression that if she went back to her mosque and they donated some Qurans, the judge would be fine with just keeping them around for future use so other people wouldn't be in her situation. She affirmed, she testified, the mosque raised money, bought Qurans, took a bunch of them, offered to donate them to the courts in Guilford County, and the senior judge said, no thanks. It's always been the King James, it's always going to be the King James. No. And so when we heard about it, we wrote a letter to the Administrative Office of Courts. We said, look, only buying one version of a religious holy text is not what's required by our statutes. Statutes is Holy Scriptures. It doesn't say King James Bible. And the AOC punted the ball and said either take it up with the legislature or file a lawsuit. Since we think Holy Scriptures is plenty broad enough to be inclusive of multiple religious texts, we filed a lawsuit. And we filed a lawsuit on behalf of, at that time, in summer of 2005, 8,000 ACLU members in North Carolina, many of whom are Jewish or Muslim that we know of, and probably some Buddhists in there, and Hindus, and who knows, right? We don't ask them when they join. So the lawsuit for the last year and a half has been hung up on the procedural preliminary question of whether we and our membership, who are not literally on a witness stand at the moment, present an actual case or controversy. And also, since we joined Saida Mateen as a client, whether Saida Mateen, the woman from Guilford County, who went ahead and affirmed and her case is over, is it moot, or does she have a live case or controversy?
That would be a great
well?
con law exam question.
It's great, I know. So in this case, it's never been brought. Most states actually don't use books anymore, but North Carolina is not the only one. And so this is getting a lot of attention. And on Tuesday of this week, we finally cleared a hurdle. The Court of Appeals, because the case was dismissed by a lower court judge who said there's no case or controversy. So the Court of Appeals said, yes, there is. And both the ACLU membership and Ms. Mateen can go forward and get our day in court on this question that really boils down to government neutrality. You know, in all the cases we look at, it's always about government neutrality. Is the government taking sides in the religion debate? Here, it's, we think, a no-brainer. The government is only buying one version of a Holy Scripture and refusing people who want to donate the rest of the Scriptures for free and saying, no thanks, we are only going to use this one. So it's interesting. Either, we hope what the court will do is say Holy Scriptures is a broad term inclusive of multiple religious texts. But if they don't do that, if they don't, we'll probably have testimony on both sides about what Holy Scriptures means, right? And if they don't do that, and they don't find that Holy Scriptures is broadly inclusive, the only alternative to be consistent with Establishment Clause jurisprudence and government neutrality is no more books. We do what most states do, which is you either swear or you affirm, but no books. It's got to be an all or nothing proposition. There's a lot more cases we work on. I urge you to check out our website at www.acluofnorthcarolina.org. I see at least 2 people in this room right now who have interned in my office. We work on very interesting stuff. Those of you that love con law would love interning with an organization like the ACLU. It's just fun. So anyway, thanks, Nadine.
You won a wonderful case earlier this year that I definitely will use in my con law class because it builds on Lawrence versus Texas, the Supreme Court's great case, upholding the right of adults, mature adults in the privacy of their own home to define their own relationships and sexual intimacy. And it was just amazing. This was under a statute, right, that a woman who worked for a sheriff's department who was living with a man to whom she was not married. Was that violating a state law or a
Yeah.
local? It was a state law that actually made that a crime, probably usually not too often enforced. But in this case, the sheriff's department said that because she was violating the law, she would either have to, lose her job or move out, not continue to live with her domestic partner. And thanks to the ACLU of North Carolina, that statute was struck down this year as unconstitutional.
All right, well, we would like to give a warm thank you.
Thank you all so much. Thank you.
I'd also just like to thank all of you for coming to our inaugural Duke Law Leadership Experience, and I'd like to just have one more round of applause for our main organizer, Jennifer Avery, if Jen would just stand up. And to those of you who are law students in the audience, I'm sure she'd be happy to take names of people who are interested in helping to plan next year's. And knowing Jen, she'll probably start, maybe not this afternoon, but next week, start planning. So we thank you all for coming, and we hope you all have a great weekend.